finally, the Convention on the Rights of the Child prohibits Australia from returning a child to a situation in which he or she will face serious human rights violations. The obligation to protect under these treaties is actually broader than that provided by the Refugee Convention, because if you've been listening carefully, you might have noticed that those treaties don't require the harm feared to be connected to a ground, such as race, religion. So, for example, a person who fears being tortured on return to their country of origin, but is unable to link that torture to, for example, political opinion, may still be protected under the Convention Against Torture. Well, of course, the most obvious, perhaps to many of you, will be the fact that despite the fact we've had some positive changes, we still have a system of mandatory detention. That is still the default position in Australia. And further, the High Court of Australia has upheld our system of mandatory indefinite detention as being constitutional. So essentially there is no legal recourse to addressing the problems with that system. This is in contravention, arguably, of the Refugee Convention, because it provides that states may only inhibit freedom of movement in unusual circumstances and extreme circumstances. In addition, the Human Rights Committee, the UN Human Rights Committee, has repeatedly found Australia in violation of Article 9 of the ICCPR, the Civil and Political Rights Covenant, on the basis that subjecting people to indefinite detention is an arbitrary deprivation of liberty. And indeed, many comparable countries do not detain asylum seekers. There are many alternatives. The UNHCR, the UN High Commissioner for Refugees, suggests a number of alternatives, allowing people into the community and requiring residency requirements, reporting requirements, release on bail, and also many European countries have open accommodation centres that actually house asylum seekers but do provide freedom of movement. In addition, as far as I'm aware, the only country in the world to require asylum seekers to repay the cost of detention. I think that's a serious issue. The second issue that I think we need to think about is the fact that many asylum seekers are restricted from very vital socio-economic rights, such as the right to work and consequently the right to healthcare. Asylum seekers who are permitted to remain in the community pending a decision on their refugee application are granted a bridging visa. However, since the 1st of July 1997, all asylum seekers who have not applied for a protection visa within 45 days of arrival in Australia are denied the right to work and therefore access to Medicare and receive no other income support. It's often called the 45-day rule. This affects thousands of asylum seekers in the community because there are many legitimate reasons why asylum seekers do not make an application within 45 days. A 2005 report conducted by a network of asylum seeker agencies in Victoria found that many of these asylum seekers are prevented from accessing mainstream housing services, which results in homelessness, risk of homelessness, and insecure housing. Further, the lack of income determines that many asylum seekers are living under conditions of abject poverty. And I think it's quite arguable that Australia is in violation of a number of provisions of international law in this policy. For example, the House of Lords recently found that the UK was in violation, or effectively was subjecting asylum seekers to cruel, inhuman or degrading treatment because of its policy of refusing the right to work and also refusing access to welfare benefits. In addition, the International Covenant on Economic and Social Rights prohibits discrimination in the right to work and in access to healthcare. In addition to that, I think Australia's policy is also contrary to international best practice. There are many comparable countries that have much better systems. So Canada and Norway, for example, provide an immediate right to work. Canada and many European states provide free of charge access to health services. And as I mentioned earlier, most European countries provide housing, provide accommodation centres for asylum seekers. I think it's also questionable whether these policies fulfil their purported aims. Often they're said to be, as I mentioned, necessary in order to prevent Australia becoming a magnet for bogus asylum seekers, but there really is a question as to whether that's supported by empirical evidence. Make a policy based on evidence, and I think the evidence is that many of these policies, particularly mandatory detention, does not necessarily have that impact. It does not actually produce those the intended result. That in fact, it actually in the long term, as we know, and I'm sure Paris will elaborate on, has inflicted all sorts of harm that we as a society then need to deal with, particularly because it applies to refugees indiscriminately as to whether they are ultimately found to be genuine or not. So if they're genuine, they end up staying. We then have to deal as a community with the mental health consequences, with the fact that children in the past had spent many years in detention. So I'm hopeful that the government would, yes, take into account international law and also see the reality.
Because we're one of the few countries that do that. Is that correct?
Look, there are other countries that have, the US, for example, does detain some asylum seekers. I think we're one of the very few countries, however, particularly in the developed world, that has indefinite detention. So in Europe, many countries have a very short stay, up to a matter of weeks, sometimes up to a couple of months. Normally the idea is to establish identity, to establish just basic facts required to submit an application, but really just a regularisation process is often what happens in many European countries, and then refugees are moved on to an accommodation centre. The idea of this long-term indefinite detention where persons can be there, I was just looking at the Ombudsman's report actually today that was handed down last week, and there are still, just in that report there were 20 cases of people who've been in detention for more than 2 years. So that aspect of mandatory detention is quite unusual.
I'll come to the social cost of the mandatory detention whole policy in a minute, Paris, but what do you feel, Julian? Is it legal, is it political, or is it purely a social?
It's political, and that arises out of a social attitude. I think the government imagines that the public at large would resist the idea of abolishing indefinite mandatory detention because they imagine that will mean that we're going to be flooded with refugee applicants. Of course, history and geography both tend against that, and Michelle's suggestion of an evidence-based policy is a very sensible one. But we in this country live with this extraordinary timid fear that if we don't bar the doors tightly, we'll be invaded by people coming here in little boats without an invitation. And whilst you can understand the Indigenous people having that concern, it's difficult to see how the rest of us can. I think one of the big goals that we need to do, one of the things to look to be able to say we're there, is a replacement system in which people who arrive in Australia without invitation, without papers, are detained initially. I don't see that there's any rational objection to that. Detained initially for health and security checks. It should be capped at 1 month with power for a judge to extend that initial detention if the circumstances of a particular case make that necessary. But after that, release them into the community, allow them to work, give them access to Medicare and Centrelink benefits. In short, let them live like human beings. You could impose on them bail-type conditions to make sure they remain available for processing and, if necessary, for removal. But, when you look at the numbers on this, I think overall from about the mid-80s through to the end of the Howard government, the average rate of arrival ran at about 1,000 a year. It was in steep decline in the last few years. The biggest number of arrivals, unauthorised arrivals, in any 12-month period was 4,100. You'll correct me if I'm wrong, Paris, but I think that was in 2000, 2001. 4,100 was the maximum number of arrivals unauthorised. At the same time, the authorised arrival rate of people coming for business, for holidays, for study, for whatever, was about 4.5 million. We have got virtually watertight borders. And for anyone to think the leakage of 4,000 in 4.5 million, to think that's a problem, they're on a different planet. So we're dealing with a numerically small problem. Second point, 90+% of the unauthorised arrivals during that time turned out to be genuine refugees entitled to protection. Why lock them up? The answer, the honest answer is to frighten them off so they won't come, but the stated answer was, well, it's so we can keep hold of them for processing and removal. Well, the genuine refugees have got every incentive to remain available for processing because they know the circumstances which give them a claim for protection. Let's say, rounded off, 10% who wouldn't qualify for protection means numerically between 100 people a year and 400 people a year, which is a pretty small number of surplus people in the community when you consider, what, 50,000, 55,000 visa overstays at any one time in the community. People, backpackers from Canada and Britain and so on. They're not causing the sky to fall in, so what's an extra 100 here or there? No problem at all. Furthermore, if that 100 disappear without a trace and never show up again, where's the harm? It just means they're living honest lives, not causing a problem to anyone. So, I think this hysteria about the need to lock people up and hold them for years on end just in case they turn out not to be refugees is complete nonsense.